Yes. Okay, Beth?
Yes.
Lisa?
Yeah.
Myself? Yes. David?
Yes.
Motion passed. Sorry, I forgot that. That's okay. I just remembered that from last time. Okay. Declaration of candidates for the office of trustee and applicants for appointment to the office of trustee. It's the same thing.
No, they're not.
Or
They're not.
it's
They're not the
not-
same.
okay.
One is for, to declare the
Declare that you want-
candidacy to
okay, gotcha.
run, and this one is that they're appointed by the board. So. Those are just, I think.
Like approving the
those are-
forms,
Mhm.
or and putting them.
Those are
into
just
our
for
ordinances.
revising the forms, is that correct?
Right,
Lucille?
yeah. The only difference between the two forms, other than that one says candidate and one says applicant, is that on the candidate one, you'll see at the bottom that it says a copy of my affirmation of tax payments. You see it just above where it says I hereby swear. And bonding request is included. I understand that the original must be submitted to the Missouri Department of Revenue. That's primarily to give the candidate, make sure they know that it's something they're required to do. And they are required to give you a copy to be kept with the declaration of candidacy. The law requires that. But for when you're appointing, that applies to a candidate, so when you're appointing, they're not a candidate. Then the next time around, if they were to file, they would be a candidate, it would apply. Assuming the law hasn't changed again between now and then.
We won't hold our breath.
We won't assume that at all.
And those were in that email today too, weren't they?
Yes,
Yeah.
yes, everyone
I
received
said
it.
I didn't.
Should have
print it
received
off.
a copy of that.
So it's, I looked at it online, I just didn't print it. Any discussion on these forms? Can I get a motion to approve them? And what, add them in? It's part of our, is it part of that ordinance?
No,
Or it's not
it's
part of
not an
it.
ordinance. It's,
Yeah, but I know
Yes.
it's part of the board of trustees and chair ordinance, or
no.
it's just
No, it's
approving
a-
it, okay.
It's just a formal document that we need to use.
Okay. Can I get a motion to approve?
I'll move approval of the document.
A second?
I'll second it.
All those in favor?
Aye.
Aye.
Opposed? Okay, motion passed. Okay, our next ordinance for review is property maintenance.
I want you to have a copy of that because this has been on the agenda since before I started, so. If anybody needs a copy, I'll be happy to run one. Or I will have my lovely assistant Jan run one.
She had a staff, she's not used to doing this.
You ain't gonna be here.
Yes, I will.
Maybe you can do it.
So I have one.
Yes.
Yes.
Anybody else want a copy?
Yeah.
Okay, make it 3. Okay. That's it?
Make it 4.
4, make it 4.
Is property maintenance?
Lorianne's always asking about killing trees. I'm just.
I know.
I ran my financial report on back, front and back tonight. Just so I didn't have, so I didn't have an extra page of paper, so.
Actually, I have a copy. It's just the ordinance as it is right now.
Yes, it's,
So
it's,
I don't need
it's
one.
property maintenance number, page 47 through 49 is what I
Okay.
have down on the agenda.
Yeah. Yes.
I don't need it, Jen.
Yes.
Sounds like everybody's saying.
We're canceling our orders.
Too late.
The second page, I'm confused.
I'll take a clean copy.
But I
I've written all of them. Wait, 47. No, I have it. I have that one and I have this one with the red highlighting. I'm highlighting.
And then I'll have time to do something else.
Wait a minute, there's a light there.
And this ordinance was passed in 2011 in May.
Well, it's a new poll too. Because they're redoing all those polls.
I wasn't here for this one. I need a better one. I wasn't here for that one. I don't have a copy of that. Thank you. That's discussed.
Would either of you gentlemen want to chair, because there's another one right here behind me?
Oh, that's all right. I'd fall asleep if I sat down.
No snoring. No snoring during the meeting. And we've got more chairs in the back if you want. I don't have to get chairs if you want. I knew I had some.
Should the other one put on there?
Well, it said it could take several minutes, so as soon as
Oh, I
I fed
see.
the other one, then it started, it went back and doing, so.
That's right. That's right. I think it's pretty clear. Pretty close, within $2, aren't we?
Okay, does everybody have a copy now? Okay, discussion on the property maintenance ordinance. Excuse me.
I don't have anything. Do you have discussion on it? Let's go to sign.
It was mentioned last time, are we covering the whole thing, all those pages?
47, 48, 49.
It was mentioned last time that, and I thought there was a passive agreement, we'll put it that way, really horrible, that we eliminate eyesore off of there because it was personal preference, an eyesore, be a personal preference. Reasonable person is not clearly defined sufficiently enough, and so reasonable person could be left up to personal preference.
I guess I think that it's important because it could say that a complaint could happen if, there was a rock someplace, and a reasonable person would say, well, a single rock or a single brick is not debris, or some weeds that just hadn't been raked up yet, that kind of thing. That it would be unreasonable to think that some single thing there is enough to be a violation. So I think it protects property owners to say a reasonable person. That's my reading of it.
So what was the definition of reasonable person
Yeah.
from that then?
Yeah.
Well, that's a term of law, I think. Isn't that a
It's
legal
reasonable?
term?
Yeah.
Yeah.
What is the
What is the
definition of
definition of
reasonable
it,
person?
Well, we have an attorney here. I don't know if she wants to speak to it.
She's not on the clock. Wow, no. I was just kidding with you.
Generally, a reasonable person, and I can't tell you specifically, but what it means is if you have the general population, if they review something, and I want to say general population, something that is generally acceptable. If it offends one person and they have a problem with that, but all the other people find it to be okay. And I will say that it's a gray area. It is in some ways subjective, but other than that, putting a definition for absolutely everything to every nth degree is just not something that's practical or something that you can actually do. So they use reasonable person, and it is a term of law that they use frequently. Wish I had Black's Law Dictionary, but I don't with me. They would probably give a better description. But it is a protection for people from someone unreasonable saying, I don't like that, or that is this. That if they are some sort of one person that believes that, that is protection from some personal subjective, that they kind of look at the opinion more of the masses. That's the best I can do off the top of my head, sorry. Beth, are you looking it up?
Yes.
Well, then I would like to hear what you find.
Well, you did pretty well. I'm trying to be selective in my source, not using Wikipedia, but using, you know.
Well, where I would go would be Black's Law Dictionary, but I don't have it, so.
Yeah.
That's probably not on mine, no, Black's Law Dictionary.
Doubtful.
Not without a subscription.
But it is a protection, so that one person's opinion isn't enough. It has to be the opinion of, more like the general opinion. I don't know if that's helpful.
Who decides what the general opinion is?
Determined, yeah.
In court.
Well, and sometimes, depending upon certain laws, that's correct, but that's kind of not where we're going here. A lot of times they interpret those kind of terms of art in case law, and the opinions kind of flesh out exactly what it means. So there probably is something in the case law that I wasn't asked, so I can't tell you off the top of my head.
Webster's New World Law Dictionary, an imaginary person who is used as the legal measuring stick against which to determine whether or not a defendant exercised appropriate caution in an undertaking, or whether he exhibited negligence by not taking the precautions that the hypothetical reasonable person may have taken under the given circumstances, or by doing something that a reasonable person would not have done. So it's a...
Are we saying that we're trying to decide whether to leave that there or to take out?
You get close to the Federalist idea or the free man idea.
Or to just mark the whole thing out? Because how can you define what a reasonable person is? Everybody would have a different idea on what a reasonable person is, because I might think somebody is completely off base and they might turn around and say that I am. And so I am not reasonable, but they are. It's just the thing, what's a reasonable person?
Well, what I would say in our ordinances, it would be what our complaint review panel would be.
Yeah.
It's not just one person saying,
No.
You voted for this and I'm going to harass you every time I turn around, and you've got a piece of wire on your property, and it says right here you can't have wire on your property. So then the three-person panel, if they get a complaint, goes out and looks at it and says, it's not reasonable to believe that that's what this ordinance meant. A single piece of wire is an eyesore, and will you pick it up, or you probably already picked it up, or your tires picked it up, or whatever it is. So it's a defense against, it's an affirmation sort of on the side of the person who might be criticized. That's what I think.
I can give you an example if you'd like, if that will be helpful. A lot of times it's used like in tort law, negligence. And they say, were you negligent in this, or were you not negligent in that? Say we have an individual, say we have a business who has some steep steps that go up to the door of their property. And on those steps, they're very steep, and they have a handle, you know, the rail. But the rail hasn't been nailed in, and it's not steady, and it's really shaky, and so someone falls and gets hurt. And so they go to sue the company because they were negligent in preparing something that was safe for their customers to come to. So it would be asking, would a reasonable person think that a company should provide a handrail for its customers that is safe. A reasonable person would expect that. And if someone said, well, I think it's not reasonable, well, then they're not going to take that person. They kind of look. If you look at the general public and you say, do you think that it is reasonable to expect a company to prepare a rail that is safe for their patrons? That's what it looks at, that sort of thing. So it's not saying you or you or you or you. It's just what do most people think of being, would you drive your car with your child on the hood? A reasonable person would not think that. So you're not looking at details. It's just kind of what a general common knowledge, people with intelligence that have the ability to think would decide. And it is a protection.
Madam Chair? So but would the judge alone be probably making that decision if it came before a judge? I mean, because the judge wouldn't pull people, right?
Well, there's so many ways that it can be applied. I mean, if it was something, and we're getting way off track here, which I don't want to do, so I'm gonna tie it up. But if it was something that was in trial, then the people who would decide if it was reasonable would be your jury, if it was a jury trial. If it was a bench trial, which means it was tried just specifically to the judge, then the judge would make the decision, but it would be based upon the arguments of the lawyers saying, well, I think this is reasonable, I think this is reasonable, and the judge would make a determination based upon the information that was presented to him. And that is if you're specifically talking in a court environment, which is probably where it's going to come up, but the concept is all the same. Is that helpful?
So,
Okay.
okay.
Okay, I appreciate Beth's comment about the reasonable person. However, I don't think that's the issue of this, of how I see that this needs to be amended. I would really like to see it be eliminated because once again, we're a small village. It goes back to the stuff that Deanne read in the beginning. Number one, it's personal property again, which you know how I feel about that. It's a violation. It's one we can get rid of that is not that important, which we were informed last time by Lucille. So if we don't need it, let's get rid of it. Let's eliminate the ordinances that really are not that applicable. Because it seems like the ones here that are really applicable, that there are a lot of strong feelings about, they get overridden by this personal, reasonable person. The main point is not being addressed.
Any other discussion?
So if eyesore is taken out, and I understand what you are saying and don't disagree with it, then violations, if you will, of number 1 and number 2, alley and debris. So it's just
I think they're pretty clear.
but then I believe that those are descriptions of eyesores. That
I think eyesore is a description of those.
okay, well, maybe either way. Yeah, either way. So if it's the same thing, I mean, that's what you would say. You have the complaint would be there's an eyesore because there's trash and garbage and metal cans and all that clothing discarded, and that's an eyesore. And I'm going to write it up and complaint review panel. Go see if this isn't an eyesore. I guess it seems to me that that's just another way of they're the same thing. That one or the
So
other.
if I have it. Okay.
Because
If debris is there and designated, creating a health, safety, or fire hazard, then why do we need the disorderly? Is that what you're asking, Lori?
Yes.
You'd like to just remove 3 altogether, remove eyesore.
Yes, thank you.
And I guess my question is, are 1 and 2 enforceable without 3? Do you have to have a title for what those things are? The offense would be, I guess, the eyesore, and the specifics are those things. So,
Would you mind if I comment?
Okay.
If you look at the specific definitions under section 4(1)(a), debris of any kind which creates a health, safety, or fire hazard, that's the general offense in most cases. Now, if it is so disorderly and unsightly, and as is commonly used as, so let's say in section 7F, it says, or so disorderly and unsightly as to constitute an eyesore. And then the eyesore comes back to the reasonable person. So if you choose to remove eyesore, you still have enforceable offenses, but they do not extend to being eyesores. They would have to be a health and safety hazard,
Health, safety, or fire
or
hazard.
health, safety, or fire hazard, or however it's specifically stated. 1B, for example, heavy waste accumulation such as brick, lumber, etc., doesn't have an eyesore component to it. It defines itself. C defines itself. Then when you get to other, I don't think we see it in section 5 or 6. In section 7,
G. F and G.
F and G have eyesore components, but they also have other definitions, health, safety, or fire hazard. So the question is whether you want to have the option. I do agree with what Beth is saying in terms of it does operate as a protection to some extent, but if you want to eliminate the eyesore component, then you would eliminate 3 and each place where it states it elsewhere.
not the whole section, but just those words.
Just those words, yes, not the sections. You retain the violation because they have potentials to be health, safety, and fire hazards or are self-defined.
That's what I want to know.
May I ask a question? Or just ask? It seems to me that what you have here is an ordinance that's comprehensive and talks about the health and the safety and those things regarding the residents, which is something you want to protect. And I don't have the ordinance in front of me, but eyesore sometimes could be... You're getting my good side here. Is the light right? I mean,
Here's a copy. The camera adds 10 pounds, I'm just saying.
then turn them off right now. But what eyesore too, and again, tell me which one it is so I can look at it closely. Eyesore, offensive to the sight. Okay. What this does is, and I think it has more of an artistic thing. There are people who like to build grandiose metal sculptures in their yard, which some people don't like. There are some people who want to paint their house, each strip of it, in a different pastel, because that is what they like. This is the kind of thing, I think, that, it maybe would restrict that. So that's something that you need to decide if you do. Am I wrong? Because that's what just the eyesore, if that's all you're looking at, it is subjective, and some people would find that sculpture as to be attractive, and some would find it not. So you're giving an ability to find a violation for something that is simply aesthetic, but isn't relating to safety or health or the welfare. Am I wrong?
Correct. Well, I think in your case, you're actually the only place where eyesore comes into play is where it is stated, not just in the definition, but in the ordinance. And in every case, it's attached to certain types of things. So I don't think you are in fact getting into it in this case. If you had a provision that simply said any eyesore, then it would be. But you do not have such a provision, so.
So you're just saying
in your
that.
case, it's tied to the specifics that precede it.
Okay, so it is tied here to debris. So it isn't specifically just an eyesore. It has to be something more. And if you are looking at
7F and G.
you guys are too good.
We've had
Okay, wait a minute. Any building or structure of any kind kept or maintained or permitted to be kept or maintained in a condition that creates a health, safety. So this isn't something that you can just pick out and say it's an eyesore. An eyesore means that it is something in addition to a health, safety, or fire hazard. And in G, again, a health, safety, or fire hazard. And you can have a violation with just that. And in addition, it may be ugly.
What
But
about
it's
the
not
or,
something.
Or. The or was.
Yeah.
Or which is so disorderly and unsightly as to constitute an eyesore shall be deemed a nuisance.
That seems like the eyesore itself is
A separate.
Separate thing.
And I will restate what I said at the last meeting, and I don't mean to interfere with your deliberations, it's up to you what you choose to do. In my opinion, deleting the eyesore provision is not debilitating to the ordinance with the intent that you intend to put it to.
Yeah, I don't.
However, that's up to you.
Madam Chairman, I would like to propose that we remove or eliminate section 3.3, definition of eyesore, and remove that word from the other places that it's used in the property maintenance.
The phrase with that, the phrase with that word in it is what I think.
So
should be.
4.1A,
F and G.
section
Including
4.1A,
F and G.
and section 7.
And section
F and G.
7, F and G.
You probably don't need to, at this point, you're not actually passing an ordinance, so you don't need to define it that carefully. You just need to know whether or not you want to delete it from the ordinance, and if so, then it can be deleted from all the places where it appears. If not, then it stays.
Okay,
Eyesore is not factual,
can I get a second on that
it's
motion?
opinionated.
You're not really ready for motions. At this point, you're just kind of getting a general consensus.
Have
And then after you have a redraft of the ordinance, then you would go with the motions and the amendments.
Okay, so is there any discussion on removing eyesore from the property maintenance? Thank you. I went blank. Property maintenance, on the sections that Lori Ann suggested.
Where else does it say eyesore besides here?
1A, section 4.1A.
Don't let any more paper stack anywhere.
And section 7.
And section 7,
What's this? And it's for, I think they passed it.
I put it where it
F
came
and
from.
G.
And
Somebody
anywhere
passed
else
it
that
to
appears
me.
if you decide to want
It's
to.
already done. I've already done
But I don't think it's in there.
When I get more home, I get it.
Once again, it's eyesore of a resident.
Say something about in
So it's not reasonable person. It's a reasonable person up under section 3.3, but when you're looking at A, in view of a resident, that's one person's personal opinion.
Okay, so we would like for Lucille, this is a general consensus, we'd like for her to draft this ordinance to change